Well, hello everyone, and thank you for joining for today's program, Shaping the Solution Using Your Best Resolution Method. The time we have for this program, I will focus on dispute resolution methods that are used to resolve disputes that you and your firms are involved with. Now, most often these disputes are with your clients, and we will talk about how you can go about the factors to consider to choose your best resolution method. In your day-to-day activities, you don't spend much time thinking about these methods because by definition, you are design professionals and not attorneys. Disputes are rare, but when they do happen, they can be a serious drain on your time. This program today will focus on the different dispute resolution methods and the factors to consider as you go about specifying what your dispute resolution method should be in your agreement. So we will talk about selecting different dispute resolution mechanisms and why, and we'll talk in detail about these methods of dispute resolution mechanisms. The first group of dispute resolution mechanisms are non-binding, meaning both parties, you and the person you're in a dispute with, will have to come to an agreement for the resolution to work. If one party doesn't agree, then whatever the results of the negotiation or the mediation are will not be binding on the other party. So these are called non-binding dispute resolution mechanisms. If direct negotiation is unsuccessful, the next step may be mediation. If mediation fails and negotiation has already failed, then you would tend to move into a binding dispute resolution mechanism, which means that somebody else, a third party, will impose a solution to the dispute that will be enforced by law. So you can have litigation or arbitration, one or the other. Remember that if there's no dispute resolution mechanism that has been selected, then by default, you will have access to litigation, which is the courts in your state. Before proceeding further, I want to emphasize that when a dispute or other circumstance has the clear potential of becoming a claim, which is a demand for money or services, you should contact your professional liability insurer for assistance and counseling. CNA offers pre-claim assistance. As long as there's been no actual claim, CNA will pay the cost of an attorney if needed to help you resolve the dispute. And reporting pre-claim situations does not impact your renewal premium. If, however, there's been a claim actually made, a demand for money or services, you must report it promptly to your insurance carrier in accordance with the claims notification provisions of your policy. So why? Well, why do we care about dispute resolution mechanisms? Although they're rare, disputes do occur, and your ability to successfully resolve disputes will impact the success of your business. We're now in an era where the economy is recovering from the effects of the pandemic, and we're expecting design firms to be quite busy. We're also in an era of material price increases, and economists are expecting inflation to go up significantly in the near future. Trade journals are already reporting that contractors are loath to guarantee prices because we're in an era of material price increases. All of these factors, in the past at least, have meant that these types of macroeconomic pressures have meant increased claims against design firms. So it does make sense for you all to take a moment to figure out exactly how your dispute resolution mechanisms are stated in your agreements. As most of you know, most disputes involve your clients. In our program, about 2/3 of all claims that are made against design firms such as yours are made by your clients, and about 70% of all the money that the CNA program pays out on your behalf goes to your clients. So to the extent that you can select your dispute resolution method in your agreement, then you at least have some idea of how this could play out. And that's the benefit of actually thinking about what your dispute resolution mechanisms should be. So what are some of the things that you should be thinking about? Your perception of the fairness of the process does have implications for the effectiveness of the dispute resolution mechanism. Your perceptions of that fairness have been found in studies to have an effect on whether or not you find a possibly unfavorable outcome to you acceptable, and on how you evaluate the neutral party. In practical terms, this means that you should avoid any client-controlled dispute resolution process because it is unlikely in reality, as well as in your perception of the fairness, that you will think that this was a fair process. So always be on the lookout for that if it is indeed something you're reviewing in a client-drafted contract. Confidentiality is also an important feature as you're looking at these options. Court proceedings, of course, take place in public. All other forms promise some degree of confidentiality. In an arbitration hearing, even if the procedure is as much as like litigation as possible, its most attractive characteristic is that it promises to be confidential. And in an environment where your reputation is important to you, confidentiality is indeed a very important trait to consider. Obviously, cost is one of the primary reasons given for resorting to an alternative dispute resolution method. Any reduced cost may be due in part to the reduced time involved. And of course, the less complex methods of negotiation and mediation are much less expensive than litigation. And also, of course, since they're informal, they can be conducted in any convenient location. So those are the features that one should look to. You always want to try and specify that you will negotiate first and then mediate before you go to a binding dispute resolution. It is also often assumed that arbitration is less expensive than litigation, but that may not always be the case. Courts actually exist in every state and in most counties, and they're already staffed. Be aware that if you select arbitration, you typically do have to pay for that arbitrator, and we'll talk about that. In mediation, you must pay the attorneys if they're brought to the mediation, and also pay the mediator fees, right? And if the case does not settle, you will still have to pay the costs of arbitration or litigation. So cost is indeed something to consider, especially if you're looking at options other than litigation in a dispute, in a binding dispute resolution mechanism. Speed is often one of the factors that are stated because courts in most states are overcrowded and trials are often delayed. Any other method of dispute resolution would probably be faster than that. A trial is probably the most rigid in terms of flexibility. Arbitration is less rigid. And obviously the non-binding dispute resolution mechanisms, negotiation and mediation, are the most flexible. So that's something also to keep in mind. And then finally, you want to make sure that you have the result that you get from this mechanism is satisfactory, that you indeed have the mechanism to have it be enforceable. And most importantly, for design firms such as yours, even though you're in a dispute, you want to be doing it in an environment that is conducive to maintaining positive relationships, even with your client who may have a dispute with you as it relates to this particular matter, but could often be the source for future projects once this issue is resolved. And if it's an antagonistic process, that totally destroys relationships, that could be a detriment to you. So it's important that you consider what the potential fallout could be and try to maintain relationships, even if you're in the midst of a heated dispute. So anytime you can negotiate or mediate a dispute, that often goes a long way to maintaining relationships. So let's go to looking in more depth about some of these non-binding dispute resolution mechanisms where both parties have to agree for the dispute to be resolved. And here's sample language of how you may go about in your contract to get this done. This comes from the E500. What this means is that you agree by contract to negotiate all disputes between you in good faith for a period of 30 days from the date of notice prior to invoking mediation. What this means in practical terms, talking to attorneys who specialize in this area, is that the 30 days oftentimes serves also as a cooling off period. So that's something to consider as you're looking at options. And when we look at negotiation principles, this is one of the most highly cited publications when it comes to negotiation principles. It's called Get Into US, Negotiating Agreement Without Giving In. And it's a best-selling 1981 book by Roger Fisher and William Uri. There have been subsequent editions of this book, and for those who are not familiar with it, I highly recommend it. This book came out of the Harvard Negotiation Project. Getting to Yes promotes interest-based bargaining over positional bargaining. And positional bargaining is characterized by parties exaggerating their respective positions in order to meet somewhere in between. It typically favors the party with superior leverage, and it's not very productive. Interest-based bargaining, also commonly known as principal negotiation, advocates that parties pursue 4 strategies that are applicable to nearly every situation. You're asked to first separate the people from the problem. Try to be able to see the problem objectively and avoid reacting personally and emotionally, which could be a problem when somebody's accusing you of having done something wrong and you feel like you're being attacked or your reputation is on the line. But at the end of the day, you want to be able to focus on the problem and not on the people. You're urged to focus on your interests and not positions, because if you're focused on your position, it stifles creativity and harms relationships. To try to differentiate between position and interest, the position is something you've decided upon beforehand. You're sticking to your guns, whereas your interest is what caused you to decide that. Look behind the position for motivating interest so that you can delve deeper into the actual problem. You want to generate a variety of possibilities before deciding what to do, and prioritize your issues first and foremost so that you decide what is most important to you. This way, you can come up with a creative solution if you have a variety of possibilities that you've looked at. Insist that the result be based on some objective standard, some professional standard, so that both parties can agree that, hey, this is reasonable. We've cited case law, we've cited other similar settlements. This is what the damage should be, and if you can point to some kind of authority, then both parties will believe that they are indeed getting a fair shake in the process. So this is, from a schematic standpoint, this is what the idea is. You're prior to negotiation, you try to build a working relationship, promote communication so that both parties have the same set of facts that they are working off of, and then discover what the other party's interests are, what is important to them, use legitimacy to develop options so that you're citing important precedent or and what typically happens in these types of situations, and then you invent options. After the negotiation, you either commit to a settlement, or you proceed with your BATNA, which is your best alternative to a negotiated agreement. And if you feel that you can't come to a process, then you need to know what your best alternatives are to a negotiated agreement. That could obviously mean going to mediation or some type of dispute resolution mechanism. But that's typically how the negotiation process works. You want to be thoughtful about it and know what the alternatives are if you can't come to a negotiated agreement. So that's briefly what negotiation looks like. Now let's turn over to mediation, where some third party is going to come in and try to mediate between you and the party you've entered into, you have a disagreement with. Here's some language that we find in the standard form agreement, and obviously you can use this or a version of this in your agreements. Now, unlike an adjudicated dispute resolution method, you still have control over the outcome. This is an informal process. It's non-binding unless both parties agree. You won't come to a settlement, but it's very successful. Over 90% of the time, mediation actually works. For mediation to work, you have to select a mediator carefully. Somebody who's qualified, has reputation, knowledge of design, construction process. The right parties have to attend the mediation. They have the ability to settle, the authority to settle, and the parties must participate in good faith. What happens is that typically the mediator conducts a joint meeting, then splits into separate caucuses. The mediator's objective is to help the parties identify, clarify, narrow, and remove barriers to mutually satisfactory negotiated settlement. He or she serves as the agent of reality, pointing out holes in each party's arguments, reminds you of the cost and time of alternatives, which at this point would be litigation or arbitration, and serves to educate the parties. Even if the claim doesn't settle, oftentimes during mediation, oftentimes what happens is that immediately after mediation, the parties move closer to each other and come close to a settlement. It's frequently required in contracts or by local courts. Many have mandatory mediation track for certain categories of civil litigation. You should know that costs are typically shared equally, and it's effective, and it's deemed to be cost effective. So those are the non-binding dispute resolution mechanisms. And in our program and in most programs for professional liability programs, this is where most claims are settled. They come to a negotiated settlement or some type of mediation. Very rarely do claims actually go through a binding dispute resolution mechanism. But we need to know exactly what methods you've selected. So we're going to talk about binding dispute resolution mechanisms. And the first one, of course, is litigation. Now, as you can see, the pathway of litigation can be very complex. This just goes to show you who some of the parties could be. The plaintiff is somebody who's suing you. Oftentimes it's you, the defendant, the design professional, and they serve you with a complaint, and they may have actually served another party, such as the contractor, with a complaint as well. The defendant may also file a counterclaim. And let's say you haven't been paid your fees, hopefully you have, but if you haven't and you feel like you owed some money, you would file a counterclaim. You may have a cross complaint filed between you and the contractor dealing with issues related between the two of you. Again, just trying to point out how complex this whole process can be. The contractor may have other subs that they want to bring in who feel that they're responsible, and you may have, as a prime consultant, subs that need to be brought in. So that's how it could fall out. It typically starts with a complaint filed by a plaintiff versus defendant. stating the causes of action. So typically the plaintiff will allege anything that they think can stick. And because the attorney wants to make sure that the plaintiff's interests are safeguarded, right? After that, typically a summons could be served on the defendant and you have a limited time to respond. If you don't respond, you could have a default judgment filed against you. Next comes discovery. This is where most of the information is exchanged. It allows each party to learn the strengths and weaknesses of the other party's case. And this reduces surprises during trial. The discovery starts with interrogatories, which are written questions submitted by one party to the other. And then you maybe serve with a notice to produce or request for production, looking for each other's records. And then come the depositions, oral questions that the plaintiff's attorney will ask of you, your attorney will ask of the plaintiff. And this could take a lot of time. Most cases, as I stated earlier, do settle prior to trial to trial. It's a settlement, effectively a compromise. And that's how it shakes out. But litigation, if it's selected, could be one way to go about resolving your dispute. The other things that could go along with litigation and clauses that relate to that is that you can designate the geographical area in which the court may hear the case. This is called venue. Most often it makes sense to have it be the state where the project is located, but some clients want it in their so-called backyard. So talk to your attorney anytime you're faced with that type of clause and make a determination whether there's differences in how indemnities or statutes of limitations, repos, and so on are interpreted under that jurisdiction's laws, and then see if it matters. Governing law, obviously, venue is the place. The law, you can state which state's laws govern. You should also talk to your attorney if the client wants to use the location, their backyard, whatever home state they are in, as the governing law provision. A judge or jury, which type of trial do you want? You can state that in your contract. Most of the times what you see is agreements to waive jury trial in contracts, because these, you may not want to deal with the vagaries of a jury, but again, that's up to you all. One thing you should watch out for, obviously, are prevailing party clauses, because that would be a clause stating that if one party prevails, then you'll be responsible for, if you lose, that you'll be responsible for the winning party's attorney fees. Those types of clauses would be contractually assumed and obligations that will not be covered by your insurance policy. So that's a decision you would have to make. So that's litigation. Again, that's the default if there's nothing stated. Arbitration is the alternative, and this is you agreeing to have an arbitrator or a panel of arbitrators rule on the merits of the claims. Typically in your contract, you have to agree on the rules for selecting arbitrators and the arbitration process. There are organizations such as the American Arbitration Association that provides standardized rules for the construction industry. And typically what you have is a panel of pre-qualified arbitrators and administration of the arbitration process. It's similar to a trial, but it's conducted in private. It's less formal. The rules of evidence are relaxed, and the terminology is different. In litigation, you don't pay for the judge, but you do pay the arbitration for the arbitrator's fees in arbitration, and that is typically split. The arbitration award is final and binding, and there's a limited right of appeal. meaning that unless there's something truly egregious, you don't really have the ability to request a review of the decision by an appellate court, and that is, an important safeguard that you often have. So arbitration can also be more expensive and take longer, and we found that many defense attorneys actually suggest using litigation rather than arbitration in your contracts. Looking at the pros and cons, really the advantages are that oftentimes the arbitrator does have significant expertise, and oftentimes they have over 10 years familiarity with the construction industry, so that goes a long way to making you feel that at least you had a fair shake. There's also the issue of privacy and convenience. Obviously, this is a private issue between you and the client, and it's not something that is in the public records. The disadvantages, talking to folks who've been through the process, is that oftentimes it feels like there are compromise awards, whereby the arbitrator oftentimes is just splitting the baby, so to speak, and deciding based on their experience what the outcome should be. And there's a feeling that there's the absence of legal and procedural safeguards that would ordinarily be quite important in a court of law. So in your contract, you need to specifically state which arbitration rules will govern. And you should also carefully review your joinder and consolidation provisions in all your agreements. Consolidation means that if there are other parties who should be consolidated into your dispute, then they should be brought in. And if that is not part of their contract, then you really don't have a way of compelling that. Joinder also means that you be able to join other parties that have the same type of petition going against, let's say, the owner, so that there is efficiency in resolving the claims. If you're a prime consultant, you should make sure that all of your sub-consultants have the same dispute resolution mechanisms. If your agreement with the client says that you have arbitration, make sure that your subs are also obligated to join in that process, because otherwise you would have mechanisms, arbitrations that will not be necessarily enforceable against the subs because they're not compelled to bring them in. So just briefly, a chart to look at how these things work out. The cost of resolution when you go from litigation to litigation goes up. What we found also is that the degree of hostility, as shown on the right, goes up. If you can settle things during negotiation and mediation, that's an important feature for maintaining a relationship. Most of your claims, as I said earlier, are settled by negotiation and mediation. Obviously, if a client makes a claim, report the claim immediately. And if your contract doesn't state what your dispute resolution mechanism should be, obviously any dispute resolution method that you discuss or are considering has to be discussed with your claim representative and your attorney. And really, the way to avoid all of this mess is frankly to focus on client relationships. And we stress that in our program, and it bears out in our experience that if the client relationship is good, oftentimes these problems can be resolved much more amicably. So that's all I have to say on this topic. I hope you learned something new. I just want to close by pointing out that we do have a lot of resources on our website. Just recently launched, we have our Victor Contract Sifter, which is our AI-powered contract review tool. you should be able to access that as an insured of our program. And this was just recently launched in May. So if you haven't had a chance to take a look at it, please go through the process to log in, and you will be contacted with an email once your account is ready. We have a lot of other resources such as our online portal and resources that are geared towards helping you manage your projects and running your firm. So if you haven't had a chance, please check out our website and the resources that are available to you. So with that, I ask you to look for the survey and provide us with your comments. And I thank you for listening, and I'll conclude today's webinar and hope you sign up for our future programs.